In this class of business environment, we'll be learning about investor protection. First of all, let us understand who's an investor. An investor is an individual or a corporate legal entity investing his or its capital in another venture or business, but does not do the business himself or itself. Means the principal company will be doing its business, but it has taken investments from some other entity or individual from outside. And these entities or individuals are investing because they want to earn return on their investments. Investor protection means safeguarding and enforcing the rights and claims of a person in his role as an investor, and it could also be a corporate entity. The capital of a company may be divided into equity capital and debt capital. The persons who contribute to the equity capital of a company are called investors. And if the debt capital has been infused, they are the creditors. The person who contribute to the equity capital of a company are called investors, and investors have the voting rights in every matter of the company and are entitled to get dividend over their investments. And their representation is done through board of directors. It is different from creditors who contribute to the debt capital of the company, who in turn get fixed rate of the interest on the money so lent. So be it equity capital or capital, both are investors, but their nature is different. First, like the anyone who's investing into equity capital is basically taking a stake in the company and giving in money or putting in capital into the company. On the other hand, debt the entities, those who provide debt capital, they are basically not the investors, rather they are called creditors, and they are providing this capital so that they can earn a fixed rate of interest on the amount they have issued to the company. There are mainly 5 acts which govern the security markets. First is the SEBI, Depositories and Participants Amendment Regulations 2019. The second one is the Companies Amendment Act 2019, which sets the code of conduct for the corporate sector in relation to issuance, allotment, and transfer of securities and disclosures to be made in public issues. Third is the Securities Contract Regulation Act 1956, which provides for the regulations of transaction in securities through control over stock exchanges. Fourth, the Depositories Act 1996, which provides for electronic maintenance and transfer of ownership of dematerialized shares. And in the regard of above 2 acts, the Securities Law Amendment Bill 2013 must be referred to. And last but not the least is the Prevention of Money Laundering Act 2002. The SEBI Act 1992 was enacted to empower SEBI with statutory powers, and this was primarily done after the economic reforms of 1991, because the government realized that more power and authority must be given to SEBI in order to check the investments being done by the private investors and the foreign private investors. The main powers which were given to SEBI was protecting the interest of investor in securities, promoting the development of securities market, and regulating the securities market. Here, SEBI acts as a watchdog. Its regulatory jurisdiction extends over corporate in the issuance of capital and transfer of securities, in addition to all intermediaries and persons associated with the securities market. So be it a broker, a brokerage firm, individual investor, everybody comes into the regulatory jurisdiction of SEBI. It can conduct inquiries, audits, and inspection of all concerned and adjudicate offences under the Act. It also has the power to register and regulate all market intermediaries, as well as to penalize them in case of violations of the provision of the Act. rules and regulations made thereunder. In a gist, we can say SEBI has full autonomy and the authority to regulate and develop an orderly securities market in India. Investor protection measures taken by SEBI are as follows. First, investor protection legislation is implemented under the section 11(2) of the SEBI Act. The measures are as follows. First, stock exchange and other securities market business regulations, registration and regulation of the intermediaries of the business like brokers, transfer agents, bankers, trustees, registrars, portfolio managers, investment consultants, merchant bankers, etc. Recording and monitoring the work of custodians, depositors, participants, foreign investors, credit rating agencies, etc. Then registering investment schemes like mutual fund and venture capital funds and regulating their functioning. Next would be promotion and control of self-regulatory companies, keeping a check on frauds and unfair trading methods related to the securities market, if any. Then observing and regulating major transactions and takeover of the companies. This has recently come into light, and in lot many cases, SEBI had to step in to check if the takeover being done or the merger being done is hostile or not. Then carry out investor awareness and education programs so that to keep them well informed and aware about all the provisions and what all they are supposed to do and not to do. Then to train the intermediaries of the business, inspecting and auditing the security exchanges and intermediaries, and last but not the least is assessment of fee and other charges. Securities Contract Regulation Act 1956 provides for the direct and indirect control of virtually all aspects of securities trading and the running of stock exchanges and aims to prevent undesirable transactions in securities. It gives the central government regulatory jurisdiction over stock exchanges through a process of recognition and continued supervision, contracts in securities, and the listing of securities on the stock exchanges. As a condition of recognition, a stock exchange complies with conditions prescribed by the central government. Organized trading activity in securities takes place on a specified recognized stock exchange, which are Sensex and Nifty in our case. The stock exchanges determine their own listing regulations, which have to conform to the minimum listing criteria set out in the rules. The Companies Act, one of the main act after the SEBI Act, which looks into the domain of investor protection, came into force from 30th August 2013. Thus, the Companies Act 1956 is overridden by the Companies Act 2013, and later on it was amended in 2019 as well. The provisions which were given under Companies Act for the protection of investors were first, civil liability for misstatement in prospectus, criminal liability also for misrepresentation in prospectus, advertisement of prospectus under Section 30 of the Companies Act 2013 lays down the provision for advertisement of prospectus. Investor Education and Protection Fund under Section 205C 3 of the Companies Act 1956 provide that the fund shall be utilized for the promotion of investors, awareness and protection of the interests of investors in accordance with such rules as may be prescribed. And these provisions given in the Companies Act 1956 were bit amended in 2013 and later on in 2019. Then other provisions given are provision related to individual shareholder rights of minority shareholders in order to see that they get proper representation in the affairs of the company. Right of majority shareholders like corporate membership rights, dematerialization of securities, the dealing which is done through demat accounts, then transfer and transmission of shares. So like who can transfer share to whom, under what circumstances, And last but not the least is conversion, consolidation, and reorganization of shares. And this particular point is very relevant, especially in the recent past. We have seen a lot many companies did certain kind of frauds in consolidation and reorganization of shares. So basically, companies at 2013 and the improvised version now, the amended Act 2019, basically looks into all these areas. Thank you.